Hello, I'm Antoinette Bone, estate planning, probate, elder law, and guardianship attorney in the Dallas-Fort Worth Metroplex. Today I'm going to help you understand why you might or might not need a trust. Let's start with the basic idea behind trusts. Think of a trust like a treasure chest. You originally bought property or earned money in your own name. You then transfer those assets into your trust name or into your treasure chest, in other words. The trust treasure chest becomes a legal entity separate from you, which now holds your property in its name and no longer in your name. Then you identify people who will occupy the three roles involved in managing trust property. First, you are the grantor or the settlor or the trust maker. All those words mean the same thing. Second, you appoint a trustee. That person or entity is responsible for managing trust assets and following directions contained in the trust document. Third, you decide whom you want to receive trust assets. Your beneficiary or beneficiaries, in other words. In legal terms, a trust is a fiduciary agreement among you, the original property owner, your trustee, and your beneficiary. The trust document contains instructions for what you want done with trust property, both for how you want it invested and also for how you want trust assets to be distributed upon your death. Trusts also contain instructions for how to manage and distribute property during any period in which you are incapacitated. Trusts are thus a very highly efficient hybrid between a power of attorney, an asset management vehicle, and a last will and testament, all rolled into one legal entity and document. There are two basic kinds of trusts to understand before they split off into their 13 or more different flavors. Those two basic kinds of trusts are irrevocable or irrevocable trusts. Let's start with the revocable trust. A revocable trust can be thought of like a treasure chest with an open lid. As grantor, settlor, trust maker of a revocable trust, you can access trust assets freely. You yourself can also occupy all three roles in a revocable trust: the grantor, trustee, and beneficiary. If need be, you can also tinker with trust terms by freely amending them to change the directions, beneficiaries, or trustees. Or you can revoke the whole thing. Before that point, though, the trust document will be there to take care of everything you want it to. If you should meet with an accident and lose capacity, the terms of your trust will designate a person to step in on your behalf and thus avoid the need to go to court to get a guardian for you. The trust will also direct who inherits, thus keeping your affairs private and out of probate court. This feature is especially important if you formerly, and then the trust after you created it, owns real property in various states. The savings in court costs in that situation could be significant. Next is the irrevocable trust. This is the trust for you if you're seeing the need for Medicaid long-term care benefits in your future, or you work in a field where lawsuits are common, such as owning a small business, being a medical professional, or in the construction industry. Now, the disadvantage of an irrevocable trust, however, is that you will be sacrificing all or almost all control over trust assets, unlike in the revocable trust situation. Once an irrevocable trust is established, you as grantor, settlor, trust maker cannot directly alter the terms, and generally speaking, your access to trust money is restricted or entirely precluded, as is required in order to enjoy the potent benefits of this kind of trust. Think of an irrevocable trust as being like the treasure chest with a locked lid. Your trustee, who generally cannot be you, is the one with the key. You yourself can no longer reach your assets. This relinquishment of control is necessary to shelter your assets from creditors or to protect your assets when entitlement to government benefits would otherwise require you to spend almost all your own first. There are ways to draft an irrevocable trust carefully so you can still exert your will over how assets are to be used. Just as with a revocable trust, you can impose conditions that must be met before a beneficiary can receive funds. You can designate how trust income is to be used for specific purposes like college tuition, business startup, or travel. You can also authorize a person or entity, known as a trust protector, who can alter trust language, correct drafting errors, or create a new similar trust if the law changes. And there you have the basics. Now you're ready to decide whether you need a credit shelter trust, a charitable trust, or a qualified terminal interest trust, or a blind trust, or just come see me to figure out all the rest. But before I go, I want to bring to your attention some things that you need to keep in mind. Some sophisticated trusts do convey tax benefits, but for the most part, the IRS considers revocable trusts to be invisible. You, as grantor, settlor, trust maker, will still pay tax on the revocable trust income, albeit at your individual rate and not at the prohibitive trust rate, which is currently 37% if income is over $13,050. As for estate taxes, trusts have no effect, but at least regarding federal estate taxes, those are currently moot for most people. They are not incurred until the value of the estate exceeds $11.7 million for a single person and $23.4 million for a couple in 2021. Some states do impose state and/or inheritance taxes, but not the great state of Texas. Visit this website to see which states have inheritance taxes. Also keep in mind that revocable trusts provide no protection against creditors. If you lose a legal action, a judge can force you to change the beneficiary of your trust to the winner. Irrevocable trusts are free from that kind of interference. Still, irrevocable trusts must be established long before you run into that kind of trouble. If you create such a trust while credit problems are looming or have already arrived, you risk that your trust will be undone as a fraudulent conveyance. Consult lawyers like me who have experience in the trusts and estates area. Custom constructing a treasure chest to fit your specific needs is a job for specific skills. I'm Antoinette Bone, estate planning, probate, elder law, and guardianship attorney in the Dallas-Fort Worth Metroplex. Call me today to get started on customizing your treasure chest. You can call me at 817-462-5454 or email me at info@abonelaw.com. I would be happy to assist you. If you found this content useful and would like to see more like it, please subscribe to my page and don't forget to tell your family and friends. Thank you for watching, and I will see you next time.